welcome to Verdictum. I'm Sheetal June, and in today's segment we will talk about the recent dismissal of two review petitions in two landmark cases by the Supreme Court. The Supreme Court has recently dismissed petitions seeking a review of its landmark judgment that affirmed the state's authority to levy taxes on mining rights and mineral-bearing lands. The review petitions were filed by the Union Government, the Karnataka Iron and Steel Manufacturers Association, and other mining entities following concerns over the financial implications of the ruling. While dismissing the review petitions, the majority bench of Chief Justice D.Y. Chandrachud, Justice Harishikesh Roy, Justice Abhay S. Oka, Justice J.B. Pardewala, Justice Manoj Mishra, Justice Ujjal Bhuyan, Justice Satish Chandra Sharma, and Justice Augustine George Massey observed that there was no error apparent on the face of the records, citing the Supreme Court Rules 2013. No case for review under Order 47, Rule 1 of the Supreme Court Rules 2013 has been established, the majority concluded. However, Justice B.V. Nagaratna, in her dissent, believed a case for review was justified, stating, having pursued the review petitions, a case for the review under Order 47, Rule 1 of the Supreme Court Rules 2013 is made out. She ordered issuing a notice to the respondents returnable within 8 weeks. Despite Justice Nagaratna's dissent, the majority view prevailed and the review petitions were dismissed. Pertinently, on August 25th, the 9-judge bench of the Apex Court held by a 8-1 majority that the states have the power to levy taxes on mineral rights, and the Mines and Minerals Development and Regulation Act 1957 passed by the Union do not limit such powers of the states. The majority judgment was delivered by the CJI and the dissenting judgment was authored by Justice B.V. Nagaratna. Disagreeing with the majority view, she had held that the royalty is in the nature of a tax and hence the provisions of the MMDR Act regarding the levy of royalty restricts the power of states to levy taxes on minerals. In that context, she had observed that I hold that the royalty is in the nature of a tax or an exaction. It is not merely a contractual payment but a statutory levy under Section 9 of the Act. The liability to pay royalty does not arise purely out of the contractual conditions of a binding lease. The payment of royalty to the government is a tax in the view of Entry 50, List 2nd, being subject to the limitations imposed by Parliament by law in context of Entry 54, List 1, read with Section 2 of the MMDR Act 1957. Apart from this, the Apex Court has also rejected the petitions seeking review of the Constitutional Bench judgment that ruled that the state has power to subclassify scheduled castes and scheduled tribes SCs-STs. The order was delivered by 7-judge bench led by Chief Justice of India D.Y. Chandrachud. The review petitions are dismissed. Having pursued the review petitions, there is no error apparent on the face of the record. No case for review under Order 47, Rule 1 of the Supreme Court Rules 2013 has been established, the top court said. The review petition was filed challenging the August 1st judgment, whereby the Supreme Court with a majority of 6-1 had ruled that the subclassification within the scheduled caste and scheduled tribes SC-STs reservation is permissible. As many as 6 separate opinions were delivered in the case. The judgment was delivered by 7-judge bench led by Chief Justice of India D.Y. Chandrachud, which overruled earlier judgments in E.V. Chennaiya case, which had held that the subclassification was not permissible because SC-STs form homogeneous classes. Besides CJI D.Y. Chandrachud, other judges on the bench were Justice B.R. Gawai, Justice Vikram Nath, Justice Bella M. Trivedi, Justice Pankaj Mittal, Justice Manoj Mishra, and Justice Satish Chandra Sharma. Justice Bella M. Trivedi, in a dissenting opinion, said that she disagreed with the majority judgment that the subclassification within the scheduled caste and scheduled tribes is permissible. In a judgment written by Chief Justice of India and Justice Manoj Mishra, they opined that Article 14 of the Constitution permits a subclassification of a class which is not similarly situated for the purpose of the law. The Supreme Court highlighted the need to identify creamy layers in the SC-STs as 4 out of the 7 judges of the Constitution bench suggested to exclude these people from the benefit of affirmative reservation. Justice B.R. Gawai had expressed his view that the state must evolve a policy for identifying the creamy layer for the scheduled caste and scheduled tribes. Additionally, the top court said that for a valid exercise of powers to subclassify under Article 16(4), it is required to collect quantifiable data with respect to the inadequacy of representation of the subcategories in the services of the state. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.